Hello friends, I welcome you all to this 15th video on law of evidence. In this session, we will be seeing section 11 of Indian Evidence Act. So as usual, let us have a brief overview as to what all we are going to study in this session. So first we will see the Bare Act provision. Then we will one by one unfold the various dimensions of section 11, in which the first is inconsistent facts and examples of it. Thereafter, we will see the facts showing probabilities, what is meant by it, and what are the various issues connected with it. Thereafter, we will see the plea of LIB and case law associated with it. And then, one very important aspect of section 11 is burden of proof in case of plea of LIB. And lastly, we will see the scope of section 11. So let us start. Section 11, the Bare Act provision reads, when facts not otherwise relevant. So facts which are not otherwise relevant, when they become relevant. So facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact, or if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. So a fact which is not relevant otherwise, it becomes relevant if it is inconsistent with any fact in issue or relevant fact, or if it makes the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Friends, these illustrations which are attached to section 11 are very important. Let us see the illustration B of it. A we will see when we will study the plea of LEB. So B states the question is whether A committed a crime. Now, the circumstances are such that crime must have been committed either by A, B, C, or D. Every fact which shows that crime could have been committed by no one else and that it was not committed by either B, C, or D is relevant. So, where a crime has been committed, and the probability is, or the thing is, that either A has committed it, or B has committed it, or C has, or D has committed it. So these are the four most probable culprits and no one else. Then any fact which shows that D has not committed it, C has not committed it, B has not committed it is relevant because it makes the probability of A committing it highly probable. Now, the first thing which is made relevant under section 11 is facts which are inconsistent with facts in issue or relevant facts. Inconsistent here means facts which cannot coexist. So if there are two things, A and B, and they are in such a manner that either if A exists, B won't exist, and if B exists, A won't exist, then any fact which shows that A was there will be relevant as far as B is concerned, and any fact which shows that B was not there is relevant as far as A is concerned. There are certain examples, and I have put one picture also, that omnipresent map. A person can be either at this place or this place or this place. He cannot be at all the place. For example, only person who is omnipresent is the Almighty God. We human beings are to be at one particular place at one particular time. So space and time dimensions are attached with us. Now, one example is A committed a rape, and the fact that his genital organs are such as to render the intercourse impossible will be highly relevant in order to defend A. Similarly, survival of Ellie's disease beyond the date of murder. That is, if we say that a person, say Mohan, has died and a person S is being prosecuted for murder of Mohan. But later on it is found that Mohan is alive. Now, this two fact that a person is dead and a person is alive cannot coexist simultaneously. They are inconsistent facts and therefore they will be relevant. The non-access of husband to prove illegitimacy of a child. So, if a mother has given birth to a child and husband is showing that for last 2 years he was not in the country, he was out of the country and he had no access to his wife, would be relevant to prove that the child is illegitimate, because it shows the inconsistent fact. It shows that both, that is father giving birth to the child, is is inconsistent with his absence. Then plea of alibi, which we will discuss later, is another example. What we have seen is from the omnipresent map. Then facts showing probabilities. So there are two types of facts which have been made relevant. Any fact which is inconsistent with the fact in issue or relevant fact are relevant, and any fact which makes the existence of fact in issue or relevant fact highly probable or improbable. So probability is also seen. But it's not only probability, friends, it's highly probable or highly improbable. So an inference as to can the two things simultaneously coexist. If the probability is that they can coexist, then they will be relevant. If the probability is that they cannot coexist, then it is relevant. So that is what is made fact showing probabilities. Now, third aspect of it is that of plea of alibi, which is very important and many a times it is used by defense lawyers in order to defend the alleged persons. So the word alibi has been derived from Latin word. Friends, this is very important because many a time in preliminary examination it has been asked the origin of word alibi, and literally it means elsewhere. Plea of alibi means that when the person who is accused of a crime, he pleads that he was not present at the scene of crime, but he was present at some other place and at such a far distance that it makes his presence at the scene of crime highly improbable and inconsistent with the fact that he has committed the crime. So the illustration A, which is attached to section 11, says the question is whether A committed a crime at Calcutta on a certain day. So crime has been committed at Calcutta. Now, the fact that on the day A was at Lahore is relevant. So crime has been committed at Calcutta and A is accused of it, but A shows that he was not at Calcutta, he was at Lahore at that point of time. The fact that at near the time when the crime was committed, A was at a distance from the place where it was committed, which would render it highly improbable, though not impossible, that he committed it, is relevant. So the crime has been committed at Calcutta. Now A, who is accused of this crime, he says that he was at Lahore at that point of time when the crime was committed. Now the distance between Calcutta and Lahore is such that it cannot be said that if a person is at Lahore, he can commit the crime at Calcutta. So this fact that A was at Lahore makes it highly improbable that A would have had committed the crime, and thus it is relevant under section 11. Now, what are the various exceptions to the plea of alibi? Friends, one exception is when the various persons are acting in connivance with each other. When there is a concept, when they are acting under the concept of joint or constructive liability. That is, they are acting in furtherance of their common intention. Then all would be liable, no matter that if a person is present at the scene of crime or not. So even if a person who is committing the crime and he is being assisted by another person who is directing him sitting at a faraway place, then the person who is directing him sitting at a faraway place, he cannot take the plea of alibi and say that as I was not present at the scene of crime, as the crime was happening at Calcutta, but I was at Lahore, and therefore I cannot be prosecuted for it. But if the fact is shown that he was directing the criminal sitting at Lahore through his mobile phone, then it becomes relevant because they were acting in furtherance of their common intention. So, friends, you see that one of the most basic question where the police asks is that where a person was on the time or at the time when the crime was committed. Now, one case law which is Munshi Prasad versus the state of Bihar. In this, the crime was committed hardly at a distance of some 400 yards from where the panchayat was taking place. Now, the person, the criminal, he took the plea of alibi and he says that as he was present in the panchayat and the scene of crime was some 400 yards away, therefore he has not done the crime. And he took the defense in the section 11 plea of alibi. However, the court said that it's not that the person is present at the scene of crime. What is important is the fact of distance between where the person claims he is and where the place of crime is. If the distance is such that it can be easily reached, that the person can commit the crime and then come again back to the panchayat, then that plea of alibi will not hold. So, presence of a person at a distance of about 400 or 500 yards from the place of occurrence cannot be termed as presence elsewhere. The plea of alibi is based on physical impossibility of being at the scene of crime, and so the distance is very material fact. So if distance is such that that a person cannot be at both the place, then it will be it will provide him a defense. But if distance is such that he can easily go to the scene of crime and come back to the place where he is claiming he was, then that will not hold as a defense. Then, plea of alibi and burden of proof. Friends, Section 103 of Indian Evidence Act states that the burden of proving of any particular fact is on that person who claims the court that about that particular fact. So any person who wants the court to believe in that particular fact has the onus of proof, has the burden of proof to prove that particular fact. Now, in case of plea of alibi, it is the particular fact which is within the knowledge of the accused. Therefore, it is on the accused, it is on the defense to prove the plea of alibi. But however, there is a sequence to it, and that was emphasized in the case of Jayanti Bhai versus Bhankar Bhai in but Jayanti Bhai, Bhankar Bhai versus the state of Gujarat. In this case, there was an altercation, a crime took place, and one of the person died. Many persons were accused and they were prosecuted and they were convicted in it. One of the person went to the Supreme Court and took the plea of alibi. Now, in this, the Supreme Court held that the sequence of burden of proof is that first it is for the prosecution to prove the guilt of accused. So first it is for the prosecution to establish beyond any reasonable doubt that the person was present at the scene of crime and he has done it, and thereafter it is for the accused to prove, if he takes the plea of alibi, that he was at some distant place so far away that it is highly improbable or impossible for him to be present at the scene of crime. It is not the other way round. That is, if the accused prosecution has not proved the case beyond any reasonable doubt, and the accused takes the plea of alibi and he is not able to prove that he was at some other place, then also the person will not be held guilty. So it is that if the prosecution has failed in discharging its burden of proving the commission of crime by the accused beyond any reasonable doubt, it may not be necessary to go into the question whether the accused has succeeded in proving the defense of alibi. So, in the defense of alibi, for first it is for the prosecution to prove the guilt, and thereafter it is for the defense to prove the alibi. Then the scope of section 11. Since the wording of section 11 is such that it seems to be a residuary section, that anything which is not relevant becomes relevant if it is inconsistent, if it makes the existence or non-existence of any relevant fact or fact in issue probable. But it is not so that it has an endless scope. Its scope is also limited by the use of phrase highly probable or improbable. The word highly is attached with the probabilities. That is, only those collateral facts are relevant or are made relevant under section 11 which are so immediate that their coexistence becomes highly probable or improbable. So not all the facts are made relevant, but only which have got a highest degree of probability or improbability. Let us have a quick recap on section 11 as to what all is important in it. So we saw that section 11 makes two things relevant: facts which are inconsistent with fact in issue or relevant fact, or those facts which makes the existence or non-existence of relevant fact or fact in issue highly probable or improbable. Then we saw that not only that when we say probability, it means the simultaneous occurrence of the two things. When we say the inconsistency, it means that whether the two things can coexist or not. Then in plea of alibi, we saw that it means the presence of the accused at the place other than where the crime was committed. And it's not only the presence which is to be seen. What is more relevant is the distance between the place of crime and where the person says that he was at the time when the crime was committed. Whether that distance is such that it cannot be reached is relevant. Then we saw in burden of proof that it is for the accused to prove that he was not at the place of the crime, and this flows from the fact that if a person says that he wants the court to believe in a particular fact, then it is for him to prove that particular fact. Then in Jayanti Bhankarwai versus State of Gujarat, we saw that the sequence of burden of proof is that first it is for the prosecution to prove the guilt of accused, and then it is for the defense to prove the alibi, and not the other way around. Section 11, the scope of section 11 is not unlimited, rather it is limited by the use of phrase highly probable or improbable. So only those collateral facts which are so immediate that its coexistence become highly probable or improbable are made relevant under section 11. Thank you, friends.